I've been advised that we are streaming now on YouTube. Uh, would, Catherine, would you like to begin, Judge Gardner?
Yes. What would you like me to do, Henry?
No, are you ready? We're streaming on live on YouTube now.
I'm all set. Thank you.
Okay. I want to apologize this morning for our connection problems and not getting started on time, but we're ready to begin. My name is Judge Henry Green. I will be the presiding judge. The other judges here with me are G. Gordon Atchison and Judge Catherine Gardner. What we like to do, this particular argument is set for 15 minutes. I would like for the appellant to tell me if the appellant would like any rebuttal time, and let me get started with the attorneys. Appearing for the appellant, I'd like to have the attorney's name, please.
Brittany Whiteley.
Thank you. And appearing for the appellee, I like to have that name.
May it please the court, Luana Bell Lloyd appears as appellee's attorney.
Okay, and this is the case of 121605 in the matter of the marriage of Stephen P. Welter. Now, I just want to advise you that we've read your briefs and we've had a pre-hearing memo prepared, and is the appellant, Mrs. Whiteley, are you prepared to make your argument?
May it please the court? Yes, I am, Your Honor.
And would you like to have any rebuttal time?
I would like to reserve 5 minutes for rebuttal.
That's fine. You may proceed with your argument.
Thank you, Your Honor. May it please the court? As you are aware, since you did say that you did read the briefs, in 2007, we had a decree of divorce entered in this case. And in that decree of divorce, there was very specific language in regards to the termination of maintenance. It was very specific as to that the grounds would include, it specifically said spousal maintenance payments shall terminate upon any of the following: the expiration of the term period set out above, the death of either party, remarriage of the respondent or respondent's cohabitation, defined as living with a non-relative adult for substantially consecutive periods of time in excess of 30 days, even if said relationship does not amount to marriage-like cohabitation under the common law of Kansas. Just below that, as far as modification for the decree, the court ordered that spousal maintenance shall be modifiable pursuant to KSA 23-2901 through 23-2904, but may not be modified or reviewed more than one occasion every 2 years. For the court to hear a motion to modify, there must exist a departure of at least 10%. Now, after the entry of the decree, between the entry of the decree and June of 2018, we had a plethora.
Just let me ask a question that will display my ignorance about this area of the law. But this was a decree that Judge Montgomery entered. It is not the adoption of an agreement between the parties. Is that correct?
Correct, Your Honor, that is.
Does that make a legal difference?
Not to my knowledge, no. It would still hold precedent that it's still an order of the court, and it would not make a difference as far as whether it was by agreement or a decree of the court.
Does it make a difference as to the latitude that Judge Montgomery has to modify his own decree as opposed to an incorporated agreement of the parties when it comes to maintenance?
Well, see, therein lies an issue as far as if we look at the case law that exists in Kansas at this time. Kansas case law is very specific that underneath En re null, when a terminating event takes place, which would be in this situation, the cohabitation, once that took place, the maintenance obligation automatically terminated. And then if you go in further underneath, it is KSA 23-2904, the court must reserve jurisdiction to reinstate maintenance. And that is where we're arguing today that the appellee's Appellee's argument does not satisfy this because the court did not specifically reserve jurisdiction to reinstate maintenance.
Okay, and there's, as I understand it, and I'll ask your opposing counsel as well, there is no factual dispute here that cohabitation occurred. I mean, that's undisputed, correct? Just from your
Correct.
standpoint. All right.
Yes, correct.
Now, please continue. I'm sorry.
Thank you. So I was saying we had the plethora of issues, and I know that they are arguing that the court had the ability to modify. We are arguing that the court did not have the ability to modify. As I stated earlier, the court did not reserve the jurisdiction as required underneath Kansas statute. Also, we also want to look at the fact that there are unclean hands in this situation. The situation was created, the suspension of maintenance was created by Appellee's own actions. She then cannot come back and say, oh, well, now I can't do this or that, and basically, in a way, have her cake and eat it too.
Let me ask is that something that you raised in your brief?
I don't believe it was contained in my brief. It's in reply to their reply brief, in response to what they had raised in their reply brief.
At the district court level?
No, at the appellate court level.
Okay. Thank you.
I would also go on to say, as far as any of the arguments contained in the reply brief, that we also have underneath Kansas child support, we have the no justification rule. I believe that can be applied to this as well, where it says that if a person's own actions create the situation, they cannot then be freed from any consequences from that. And so I would say,
Judge Montgomery was aware of all those circumstances when he ruled to, in effect, continue the maintenance, right?
yes, he was.
I mean,
He
that was all
the-
presented to him. I mean, he was well aware that Kiara was something of a wrongdoer here.
Yes, he had been the judge that had sat for each one of the hearings that we had had previously in regard to what all was taking place and the issues that we were having, yes.
Okay, so why doesn't he have the authority then to, in effect, again, modify his own order here? Isn't he the master of his own order?
Well, again, it goes back to the fact that he did not, in the original decree, he did not reserve the jurisdiction which is required underneath state statute. So he would not be able to modify that decree since he did not reserve the jurisdiction to do so.
Doesn't that statute about reinstatement distinguish reinstatement from modification in saying that reinstatement, you must reserve jurisdiction to do so? But modification is separate, is it not?
So modification actually comes under, I believe, 23-2903, where a court can modify. However, the issue there is that appellee never filed a motion to modify. And
So-
it actually states that you have to have reasonable notice of the motion to modify. Appellant did not have that in this situation, so therefore the court would not have had the power to modify the decree.
So your argument is that the judge cannot sua sponte modify a maintenance order.
Correct. Correct. So, and as I've stated before,
Does that undercut the whole notion of his suspending the payments then? I mean, aren't you arguing against the position he originally took? I mean, because he modified it to suspend the payments for 9 months to equalize for wife's or ex-wife's misconduct.
I don't think it does undercut, because in that situation, we had actually filed the motion. So there was, the statutory requirement was met as far as reasonable notice to the person that is paying the maintenance obligation. That's where it really lies, is that it has to have, the person that is obligated to pay maintenance must be given reasonable notice and an opportunity for hearing. Obviously, we were the ones filing the motions, we had reasonable notice of the situation for him to modify that. And we were actually requesting that modification because there was the issue of my client was having to pay not only the mortgage on the house, but then also pay the maintenance obligation, and pay those two things would be very difficult to do. And wife wasn't allowing the sale of the house to go forward. she was holding up the sale of the home, which was causing a greater financial burden for the ex-husband.
Ms. Whiteley, you have 2 minutes before you get into your rebuttal time.
Thank you, Your Honors.
You have 2 minutes before you get to your rebuttal time.
Thank you. So, like I was saying, in June of at the 31-day mark, the termination was met. We do not have any issue here of the judge being able to reinstate because of the statutory factors not being satisfied. And as far as modification is concerned, as I stated before, the appellant did not have reasonable notice and an opportunity for hearing before that modification would go through. Thank you.
Let me ask you one question there. What date is the 31-day mark? If we agree with you, as of what date? I mean, she started cohabiting in June. So would you
She
say
actually started cohabitating in May of 2018.
Okay.
So I believe, based on the testimony, because we didn't use an exact date, but I would say June 30th would have been the termination.
Thank you.
Are you finished with your argument?
Yes, I am, Your Honor.
Okay. Appellee, Ms. Bell Lloyd.
Thank you. May it please the court. I
Before
will
you
first,
before you get rolling, let me ask you the same question. Factually, there is no dispute that there was cohabitation within the meaning of the decree, correct?
I think that is dependent upon what the meaning of the decree is. There is no factual dispute that Ms. Welter resided in the same home as her boyfriend during the period of time found by Judge Montgomery.
I'm not trying to split
believe
hairs here. Judge Montgomery found that there was cohabitation within the meaning of the decree, correct?
Yes, he found there was cohabitation, but I think what isn't
Well,
really
and you're not
clear,
disputing that. That's not an issue on appeal, is it? You're not disputing that finding.
it depends upon what Judge Montgomery defined cohabitation as. And the reason I raise that issue, Judge, if you look at the transcript of the proceedings that was filed in this case, when Judge Montgomery is going through his rationale, he references that he put the language in about residing with a third-party non-relative adult because he wasn't wanting to limit it to a same-sex type of situation or a
Well, I read
wanted
what
to
he
include a
ruled.
same.
You haven't raised an issue on appeal that factually contests whether there was cohabitation within the meaning of the decree. You're making a legal argument, aren't you?
I am not contesting that she resided with the third party. I am contesting that there was cohabitation under the Wesleyan and Kuzanik argument, which was contained within the appellant's brief.
Okay, go ahead.
And that was one of the issues here because the judge also noted that this wasn't a situation where she resided with a roommate, et cetera. And certainly under the Kuzanik and Wesleyan cases, the only evidence the court had here was that Ms. Welter resided under the roof of a boyfriend. We admit and don't dispute the fact she did not pay rent nor utilities, but in exchange provided daycare services for the boyfriend's son. These parties own no joint accounts, own no property together. It's undisputed the boyfriend didn't provide her any money, nor any form of support that would rise to a living in a marriage-like relationship. But if we're going to construe it just residing under the roof, then yes, there is no factual dispute in that respect. And again, I know when Judge Montgomery went through his analysis, I don't know that he really concluded that there was cohabitation under the Wesleyan and Kuzanik cases, or simply there was a cohabitation because they were riding under the same roof. And I think that's hard to discern from his reasoning as he's going through his analysis of the case, because it almost appears as if he would have found that if Miss Welter had simply resided with a roommate in an apartment and was sharing rent, that perhaps he wouldn't have terminated or considered a termination of the spousal maintenance under his definition in the decree that provided for merely residing with a third-party non-relative adult. And I think that's important because I do think we know for a fact whether a marriage ends by death or whether maintenance terminates by death or whether maintenance terminates by a remarriage. We may have an issue whether the marriage is void, but we know those events occur. I don't believe that Judge Montgomery's decree set a clear, precise line under what residing together was going to need to rise to in order to justify a termination of the spousal maintenance obligation, which is why we're back in court. And I do believe the court has the jurisdiction, sua sponte or otherwise, to modify its own order. If this were a separation agreement.
Yes, I was just going to ask if you have some case law in support of that belief that the court does have the power to modify maintenance sua sponte when the statutes do seem to speak in terms of emotion.
Well, I think that the reason in this case is because the issue was whether or not the maintenance ought to be terminated. And in all of the responsive pleadings in this case, it was the Ms. Welter's position that the facts did not give rise to a termination of the court's spousal maintenance obligation. So I believe in entering its ruling, the court had jurisdiction to modify its order, if you will. And this wasn't a modification where Ms. Welter was asking for an increase of support or Mr. Welter was going to ask for a decrease of support. So it in essence wasn't a modification of the support order as it related to the dollar amount. It wasn't a modification of the support order as it related in essence to duration. It was simply an issue of termination and what that ought to entail, which was before the court.
Does the marriage of quint control here? And if not, why not?
I'm sorry, I didn't hear the first part of your question.
The Supreme Court case in the marriage of quint, which I think has been cited, deals with a situation where there was a remarriage, and the court found that upon the remarriage, there was an automatic termination. Why doesn't that, by analogy, apply here?
Because clearly a court has the ability to determine when there is a remarriage. We've got marriage certificates, we've got clear evidence, and I think in looking through that, and they cited the case of Hersmark, 199 Kansas 48, a 1967 case, which I believe also established through that quint analysis that there can be a prima facie showing that perhaps there ought to be a termination of maintenance, but the other party is given the right to plead some form of special circumstances or extraordinary circumstances, which may warrant the court in not automatically terminating the spousal maintenance obligation. And that was one of the main arguments we had here in our brief, is that this case did involve special circumstances because during the time that Ms. Welter cohabitated or resided under the same roof with a third party, there was no spousal maintenance order. There was no award. Judge Montgomery clearly in his orders, and he did it on 2 separate occasions, he had either suspended or abated, terminated, whatever term we're going to use, the spousal maintenance obligation. So there wasn't even an obligation that was in place. This was not a situation where Judge Montgomery entered a judgment award of X amount of dollars and then told Ms. Welter, you have to pay it, or enforceable through a wage garnishment or otherwise. It was an issue where the judge on his own made a determination that he was going to temporarily terminate or suspend Ms. Welter's spousal maintenance obligation. And I think that is a significant circumstance, special circumstance, which Judge Montgomery can consider in entering his order in the case.
Let me ask you about that, because you're saying this is a special circumstance like in the Herzmark case, but I don't think the language was that broad. I think the court simply said remarriage raises a prima facie case that the maintenance should terminate. And then the only special circumstance I believe the court talked about was a void marriage. So by analogy here, the only special circumstance we could consider would be the fact she did not cohabitate. And that doesn't seem to be an argument that's really been very well preserved, if at all, in this case.
I'm sorry, Judge, you cut out just briefly on the last part of your comment on the cohabitation part.
Okay, I was saying that here, I think the only argument you would have that's analogous to Herzmann is that she did not cohabit within the meaning of the divorce decree. That would be the analogous situation to the void marriage. And I'm not sure that you had preserved that argument.
I don't believe that the Quint case can be construed that narrowly. Again, the court was only focusing on the issue of a remarriage. And in that respect, I don't think limited or provided any definition on what special circumstances could be. And again, in this case, it's hard to tell under Judge Montgomery's definition. Is residing together, are we looking at the same factors as Kuzanik? He references that case, or did he merely determine that they resided with? But again, I don't think you can anticipate every single special circumstances that may arise in a residing / cohabitation case under the Quint analysis, particularly when you consider the Herzmark case. On special circumstances. And also too, I think, there clearly if a marriage is later determined to be void, the court does have the authority to go back and reinstate a prior maintenance obligation under Kansas law. I realize it's not if it's voidable, but void. And again, under the case here, Ms. Welter did not reside with or cohabitate with anyone during any period of time she was receiving spousal maintenance. And in fact, was simply waiting on her own property and premises to become available the 1st of February. So she, in fact, had ended the cohabitation, and I don't think can be considered was in any marriage type relationship if we're going to use that type of analysis. I just simply believe, a court in a domestic action has the right to interpret its own order, which I believe Judge Montgomery did in this case. The court has the authority and jurisdiction in a domestic case to do equity. And I certainly believe it's inequitable. And I believe that Judge Montgomery considered all those factors and saying, look, by the way, I'm just going to terminate your maintenance, which I've already concluded that you need to live on. So I'm just going to take 100% of that maintenance away. And, oh, I'm sorry now, I've got you. Now you have to go live with someone else because you have no roof over your head or no means to support yourself when your maintenance has been ended. And I think that was also considerations by the court. And I think the court did do equity, and certainly we're not contesting it. And we've not appealed the issue that the maintenance term was reduced by 9 months under Judge Montgomery's ruling.
Have you completed your argument?
Yeah, I just have a couple of follow-up points. Again, I don't know how much time I have left.
You have 2 minutes left.
Okay.
2 minutes.
Again, I don't believe in responding to appellant's brief. This is an issue of reinstatement. Clearly that statute, what was intended for, that in order for Mr. Weltner's spousal maintenance obligation to be reinstated or extended. I agree the court would have had to have retained jurisdiction, such as when the original maintenance period expired. I acknowledge that Ms. Welter wouldn't have had a right to reinstate after the term, but that's not what the judge did in this case. He kept the spousal maintenance obligation within the confines of his original order. He did not increase any liability on behalf of Mr. Weltner to provide spousal maintenance in this case. And again, I think it's a question of how we're going to interpret what residing with meant for Judge Montgomery. And I think that's what he considered insofar as entering his orders in this case.
Are you finished with your argument?
Yes, I am. Thank you.
Thank you so much. Ms. Whiteley, you have your full 5 minutes of rebuttal.
Thank you, Your Honor. It had been stated on that it was undisputed that the significant other did not provide any financial assistance to Ms. Welter. I would actually disagree with this in the testimony. The record does show that he actually did provide her financial assistance, not only through he was paying the mortgage, the utilities, and all those things, but he also paid for her cell phone. He also paid for her vehicle insurance, and I believe it was also fuel for her car, paid for those types of things, gave her, so she did have a financial gain from this. Judge Montgomery was also very clear that he believed that there was cohabitation underneath Kuzanzik. And I would agree with the judge on that point, that there were colorable attributes related to marriage in this situation, that the parties were playing, in lack of a better term at this point in time, but playing husband and wife. Now, as far as the order was concerned, during the time when the termination took place, the order was merely suspended. That doesn't mean that it was terminated. So the order still existed, and it still had in place the requirements underneath the decree that it would terminate if she cohabitated. And this isn't a situation where Ms. Welter is entitled to any sort of equity. This is going back to the unclean hands doctrine, that you cannot be entitled to equity when you're the one causing the issue, when you're the one creating the situation. And this is just a claim that this was her only option. There are many other options, and that was also one of the things that Judge Montgomery brought out in the testimony on the record, is that there were other options available to her. Now, based on the fact that this maintenance obligation terminated automatically the minute the elements for termination were met underneath the decree, and that the judge, because in the decree did not reserve jurisdiction to reinstate maintenance, we believe that underneath both In re Null and In re Crawford, that it was appropriate that the maintenance should have been terminated. The judge did find cohabitation. The appropriate step would have been to terminate maintenance and not to modify it as he did. As I previously stated, my client did not have reasonable opportunity or reasonable notice for any sort of modification, and I do not believe that the court has the right to sua sponte modify the divorce decree. We do request that this court reverse the district court's ruling and remand this case for further determination. Thank you.
Thank you. We appreciate both of your arguments, and we will take this case under advisement and issue an opinion as soon as possible. Are there any questions?
No, Your Honors.
No, Your Honors, thank you.
We appreciate your arguments, and again, we apologize for the delay in getting to your arguments. And have a good day. Thank you.
Thank you. Thank you as well.
Thank you.